All right, members, let's get started. We've got a couple of members that may be joining us late. Holly, if you'll call the roll for us.
Senator Albritton, Senator Bell, Senator Carnley, Senator Coleman Madison, Senator Elliott, Senator Figures, Senator Gavan, Senator Orr, Senator Singleton, Senator Smitherman, Senator Stutz, Senator Weaver, Senator Barfoot.
Here.
8, and we have a quorum.
All right. First of all, you will notice in your package that SB 159 was added to the agenda, a late addition. That was a result of some work that had been done over the past several weeks, and we'll address that if we get that actual sub printed in this morning. But it is on the agenda. I want to say thank you to Holly because she was up with the chickens this morning, making sure that everything got done that needed to be done that we could at that point. That being said, Senator Gavan, SB 39.
Thank you, Mr. Chairman. So everyone should have a substitute in front of you today. And this was, I hope, in final version. And somebody said, congratulations on getting this worked out. And I said, I hope, I think. So, but a lot of people have worked with me on this. What this substitute does, I had said that my bill that we're substituting this, if the committee so chooses, was a Band-Aid bill. This is not a Band-Aid bill. This is, which Senator Smitherman spoke about several times, this is all of the needs listed by AOC. This is not intended as a, I want one too, me too. This is what AOC says we need, every one of them, okay? And it's all across the state from north to south, scattered about. And, but it also, what we did was we looked at, because there has been an ongoing debate about how is AOC calculating the case numbers. And, you know, it strikes me that if there is someone is arrested and they may have 5 different counts against them, that's one case, not 5 cases. And so we have added some language in here that we are, if you look on page 6, beginning on line 154, that the AOC shall provide the following statistics for each fiscal year by circuit. And then that's the number of civil cases broken down by category, number of civil cases resolved via motion to dismiss or voluntary dismissal, the number resolved on motion for summary judgment, the number of cases for which a jury is impaneled, and the number of civil cases tried to a jury verdict. And then it goes down and breaks down the criminal cases, and then it says that the information provided by that is going to be provided to the Speaker, the Pro Tem, and the Senate, both the budget chairs, and then in the House and the Senate, and then the Judiciary chairs, and then the Legislative Fiscal Officer. I think this will get us going forward in a positive manner. I think we will get better information. We also have in here, and we're putting a hold on the Judicial Reallocation Commission meeting until 2027. I don't think that that's a problem in that I believe if we pass this bill, we take care of the needs that are out there. We put the water on the fires, and we're able to, I think, comfortably get past 2027 as far as any other needs that are out there. So I'll be certainly open for questions.
Senator Smitherman.
Thank you, Mr. Chairman. Because, you know, you and I have had a lot of conversation about this, so let me clear that up. I don't want to seem like I'm naive and don't know. Of course, this version, I just saw this morning when I walked in here. And so I through my scanning, gather many of the things that you just said. Probably the area I think that we need to look as we go forward to maybe some a little additional work is that as they go forward, the usage of everything that you put in here, uh, and how it might be considered, such as, like you just said, you got it in here now. Just like we were saying in the criminal cases, counts. You know, that to understand that each count is a separate trial. Because if you only went in there on count 3, just imagine this. You throw out count 1 and 2, and now it's 3. That's a trial. So as a lawyer, you got to literally try every one of those counts in one trial. So that judge is handling 3 different trials in the time frame that it took to handle the 3 versus if it was just 1 count. And I think you and I know that it takes a lot longer for someone to argue or point that this is not it, or argue the motions that they filed, and as relates to that 1 count. So I would like for us to get closer to narrowly defining how that's the application of that. The second thing is that you and I talked. So I hadn't seen it. It might be in here what I'm getting ready to, what I'm getting ready to say, because I hadn't seen it. The other thing is that many times people have a tendency in positions, and I don't mean us, but I'm talking about appointed positions, in particular, to want to flex their muscle as to, because I got the power, okay? And here I had a conversation regarding, and I have a tendency to agree with what you just said, by the way. I want to say that when you hear me talk, you're going to know what I'm talking about. But they had a power, said, because somebody got 2 more after we done did the formula, we talked about it, 2 more over here, but ain't no need. I'm finna get 1. That is not a proven need. So we talked about being specific, that it doesn't matter whether they determine somebody's got 2 more extra or 3. If ain't nobody out there got a need based on the allocation, then you don't take nobody's stuff just cause they got a plus. And so I would like to make sure that's clear. I'm not worried about y'all and us, but we ain't on the reallocation commission. You see what I'm saying? So that's that. That's the second thing, that we mentioned, or that I mentioned, in conversation, and of course, at the same time, it's my understanding that Justice Stewart and that committee also had some conversations and discussions with that I think in part what you put in here will help, because we'll be able to have that information as we go forward as a group, to see, whether or not they actually are applying some of these things in the formula, and what impact they may or may not have on the work that people do. So I just said that to say that part that if you can respond, whether or not, like you might say, on page 5 it's sitting right there, on page 6 it's sitting right there. I don't know, because I hadn't had a chance to really this morning look carefully.
I don't think that's explicitly set out. And there's another thing has come up, which you refreshed my recollection on that. And I don't remember whether you suggested this or somebody from the court system suggested this, that Justice Stewart and others are working on some criteria. We don't want to exclude those criteria. We just want to add this in addition to it. So I think those are some tweaks, because I think it is implicit that for there to be a reallocation, that there's got to be a need somewhere. You don't just take something to give somebody else something because somebody's got more power or, feels froggy that day. But but I don't mind being clear about that, about the intention of it.
I appreciate that. Appreciate that tremendously.
Senator Weaver.
Senator Gavan, this would typically be a question I would have a discussion with you offline about. Say, forgive me for asking this here in the middle of the committee. In the original bill, I know there's been some discussion related to Shelby County, and I've had some meetings at home, and my Shelby County judges are very feel that they need some representation in this bill as well. In the original bill, was Shelby County, and I'm looking through and I don't see it in either version, but at one time was Shelby County included in this, and has it been changed since
So
then?
the original, and there's a reason for confusion because there's multiple bills out there.
Okay.
And this is very similar to some of them. Shelby County gets a district judge in this one.
Okay, thank you.
Sorry, Senator Bell.
Yes, another one or two questions. One thing, if we're going to add additional judges, what about DAs? Or at some point, we're going to have to address that issue. I know that's not something today, but as a general fund.
The text have been lighting up.
Oh, I hadn't.
Especially coming out of
actually,
Baldwin County.
I have not seen the text.
Yeah, I can't slay all dragons
know.
with one swoop of the sword.
What about as general fund chairman? I mean, are we going to be able to fund
We
these? I guess
discussed
is
it
my
yesterday.
question.
I don't know what the answer to that's going to be, but he was over at my desk yesterday having that conversation.
Senator Stutz.
Thank you, Mr. Chairman. I've got a couple of questions. How, as far as what the judges we have now being properly allocated, where do you say we are on that continuum?
On how they're properly
Yeah,
allocated.
as far as caseload, I mean, how much difference is there in distribution of caseload across the state? That's my first question. My second question is explain again why we're not doing anything different for 4 years, why the delay to 2027?
So, to be blunt, it's do we want this or do we want nothing? Okay. The next meeting would be in 2024, and then there'd be one in 2026. So there's two. During that time period, the way that this is set up, only 2 judges could be reallocated from a particular county to others, and part of it is senators simply picking your battles. And, whether everything's reallocated perfectly, I can't speak to that. And part of it is because it's not all apples and apples. There have been some abuses from a particular county that's not mentioned in here in any way or form or shape. And it ain't Jefferson County on manipulating some numbers. So that's part of what we want to do with this is bring it on a level playing field.
Members, any more questions? I'd entertain a motion.
Let me ask you this: that if that's not in here, what I said, and of course you didn't, obviously you say you're having a problem with it. Could you?
So we got a text.
Okay.
The reallocation commission statute states that if there is not a need, then no move, even if there is an overage in the circuit.
If we can have a restatement of that in here, I would appreciate that.
Well, I mean, if it's in there, I can show it to you. I mean, we're not going to change it. So if it's already in the law, it's in the law. But we can look at that in the books and not just a text.
Okay, all right, because you understand what I'm saying.
I understand.
Yeah, it's I don't want to lean their interpretation to what we as a body decided to do because they ain't judges. You know what I mean? I ain't talking about the judge. I'm not talking about Judge Stewart, but I'm talking about this commission. I went to a meeting. They ain't judges. All of them ain't judges. So that's what I meant when I said that. So if we could take a peek at that, I appreciate that as we move forward in this document. Okay.
Thank you, Senator Smith.
And let me say this to the committee. If you had a chance to see the sub that I was presenting, and by the way, I actually have the sub in a bill form. I just never did put it in. It's a blue jacket sitting on my desk right now. Been there. But we were talking about 2030. Okay, so we're only talking about 2027 now. So it's obvious you can see that there's been some compromise. I just want people to understand that.
Yeah, we split the baby on it.
Yeah, we got a knife and said we're gonna split the baby without killing it. So we split it down the middle. Thank you.
King Solomon could not have been any wiser.
Yeah.
So I'd entertain a motion.
So move favorable report.
Move for,
Second.
move for favorable, Senator Van, Senator Smitherman, second. Let's get a good roll.
Senator Albritton, Senator Bell, Senator Cornley, Senator Coleman Madison, Senator Elliott, Senator Figures, Senator Gavan, Senator Orr, Senator Singleton, Senator Smitherman,
Aye.
Senator Stutz, Senator Weaver, Senator Barfoot.
This is on the adoption of the sub. Is that your motion?
Mm-hmm.
Anybody, that changes anybody's position on the adoption of the sub? All right. I'm an aye. Sub is adopted. Thank you, Senator Elliott.
Yeah, and I've now moved for favorable report.
Motion for favorable on the sub.
Using previous role without.
Second.
Second, Senator Smitherman, no objection using previous role. SB 39 is given a favorable report. Thank you so much, Senator Van. Next, we're going to jump around on the calendar a little bit.
Let me say this, Mr. Chairman. I got a public hearing on a bill at 9:30 in education, and I need to handle the second one.
Let's go ahead and do yours then, and then
In
we'll
fact,
get
I
the
need to
Director Ward after that. I know he's here, so we'll go ahead and handle your SB 64 that you're carrying for Senator Singleton, I believe.
And can represent England as well.
Okay,
So I just want you to know that.
go right ahead. You're going to have to deal with Senator Ward, Director Ward on that, but
Oh, if he got to get back over there and take out some folks, I'll bag off of it.
well, I think there's an amendment. Let's do SB 64, Senator Smitherman.
Thank you. It's self-explanatory as you read about the age of the individuals, and the amendment moves it from 70 to 75. So that's what I would offer, the amendment.
And I believe y'all have a copy of that. It's just a simple amendment. It moves age 70 to 75, as Senator Smitherman has said. Move for adoption amendment by Senator Gavan, second by Senator Bell. Any opposition using previous role? Senator Stutz, you're a no. You want to be a yes on that?
I was just wondering why you wouldn't move it to 80. You know, the new 70, the new ages are just new. Anyway,
No, I can answer you. I'm a conduit. This thing is a bill, so I didn't want to.
No, I'm not being serious, Senator. Just teasing. Thank you.
All right.
All right. No opposition to using previous role. We'll add Senator Stutz as a yes on that amendment. Is that correct? And we're back on the bill as amended. I just want to say thank you, Senator Smitherman, for stepping in for Senator Singleton. Important issue for him. I know, we talked about this a little bit before we came in. My concern is that, it is harder and harder to get folks to participate in the jury system. And certainly the folks that have lived longer and have more life experiences, I think it's a benefit to the judicial system to have them to participate. I know you agree with that and feel the same way. They bring a lot of life experiences and wisdom to that jury pool. So that's my hesitancy. I appreciate the amendment, and we'll vote to get this bill out of committee today. So
Thank you, Mr. Chairman. And our conversation extended a little further. It's simply that conversation simply said that if the jurors on there can stay until age 75, then we telling the judge you got to go home at 70. And yet the judge is only the traffic cop. The one who decides innocent and guilt is going to be 75, not the one who's driving the train, which is the 70-year-old. 69 and 70-year-old. So I just shared the conversation. I'm not going to take it any further, but we went into both sides of that aspect. So it may be something that you all may want to think about as you go forward.
thank you so much.
Thank you.
All right. Had a motion by Senator Coleman Madison to move as amended. Senator Elliott, second. Any opposition, use the previous rule. Hearing none, SB 64 is given favorable report. Senator Smitherman, I believe you're also on HB 13, and that is Representative England's bill.
Thank you, Mr. Chairman. This bill, if you've been keeping up with any of the news, they've been off and on the news for a long time, that officers are just basically saying that in these situations, and the DA's office is up on my end. I don't know about you all, but saying that, we suggest that if we can be able to, on these kind of things, write the citation, we can go out and get people, because with limited number of police officers, they'll have to take these cases and walk through the same process if a person was a murderer. You got to go in, you got to get the warrant, you got to stay there, you got to sit there and you got to do all that for these when they're saying that if they can have this option on these, because if they don't show up, they're still going to pick them up, but if they can have these options where they can give citations on these, then it'll help free up our officers even more to deal with violent crime and street crime.
Have a first, Senator Van, second by Senator Figures. I do have a concern, and I want to try to work. Senator Smitherman, are you going to work? Are you going to handle this on the floor?
I will.
I'd like to talk to you about it, Representative England, to see if we can come to an agreement. I'm all for let's trying to get it out of committee today.
Okay.
Just I'll come to you and make that a priority for me to come to you. So
I won't do anything until you and I talk, or anybody else who wants to talk.
And thank you for that commitment. That being said, any opposition using previous rule? Hearing none. Mark Senator Bell a no on HB 13. That being said, HB 13 receives a favorable report. Thank you, Senator Smitherman.
Thank you all.
And you still got a little time. We can hear Director Ward.
I do.
Let's call up SB 248. Director Ward, would you come and tell us what this big bill does?
I'm glad to be back in front of you guys again.
Yeah.
I'm sure
Glad to
everybody
have you.
says the same thing when they come in here, don't they? First of all, this bill, it was something we've worked on for the last 2.5 years of my 3.5 years at the agency. And if you really want a good cure for your insomnia at night, this is the bill to read. It'll take care of you. At 91 pages, it could have been an ALI bill, to be honest. This bill makes no policy changes whatsoever. Here's how we came up with this bill. So in 2019, Representative Rowe sponsored a bill, and actually I carried it in the Senate, so therefore I am now a creature of my own actions, is a bill that in 2019, they separated the board from the Bureau. You have the Bureau of Pardon and Parole, you have the board. The Bureau, which I oversee, handles the administrative function, the oversight of those on probation and parole. The board grants or denies parole and pardons. And so the 2019 legislation that was passed separated the two. Previously, the director worked straight for the board. They were one entity. The problem is when we passed it in 2019, you have language throughout the Code of Alabama that is very confusing. So in some cases, the board does this, the Bureau does this, but they interchange with each other. It's created a huge legal headache for our staff because oftentimes you can sign contracts, you have leases, and the code, when we changed it in 2019, just didn't delineate between the two agencies or the two groups. So what this bill does is we had to go through the entire Code of Alabama to say, okay, based upon the 2019 legislation, we want to see the Bureau is doing this, the board is doing this. Let me give you a real world example. So right now, if I go in under the 2019 statute, I can sign anything contract-wise on behalf of the board, and I don't have to notify them. Well, it works right now because I have a good personal relationship with the board. However, we've had directors who did not have a good personal relationship with the board, and it could be used in a bad purpose. We talk now, but technically under the law, the director, my position, does not even have to talk to the board. And I think that's bad public policy, and I think we need to clear it up. So I know y'all have heard this a lot. It's a long bill, but it's because we had to go code section by code section by code section to show where each person was involved and what their issues were. Again, there's no policy changes. However, there is an amendment, Mr. Chairman. I think we passed it out. And let me explain that very quickly. And I'll be glad to take any questions from the committee. the Alabama County Commissioners Association had an issue, and I think they're correct in looking at it. They're correct in that for whatever reason, when we drafted this, there was a concern that dips and dunks, which are your technical violator penalties, we changed it for whatever reason in drafting from days to hours. County Commission Association said, we want to go back to the original version of the bill, original version of the law that says it'll be counted as days and not hours. We take care of that. Second, we have a few amendments, and in short, what the amendments do is making sure there's no policy changes, and we go back to the original law as it's written. There were some changes made that were policy driven that I don't want that bill to be, we can do that as a standalone bill, but I don't want to do it with this piece of legislation because we're mainly dealing with a bureaucratic issue that deals with how we handle legal functions. And the name change is what we need, not necessarily any kind of additional policy. So that's what this amendment does. But Mr. Chairman, I'll be glad to take questions from anybody in here about what, it is a confusing issue. And I'll be the first to tell y'all, since I left sitting where you're sitting at, Mr. Chairman, I've gotten a PhD in some of this. So I feel like I'm getting pretty well versed on it. So
Very good. Senator Coleman Madison, and I, you're certainly free to address the bill as a whole or the amendment, but that's up to you. But Senator Ward's here for explanation.
Well, I haven't read the whole bill, but, and I was looking at the amendment that's here that was in our packet. This is a very short
no,
amendment.
ma'am, there's a
And I
new
was
amendment.
wondering,
I think they passed out the new amendment. Yes, ma'am.
Yes.
What we did was, as opposed to coming with a substitute or several different amendments, we addressed it all in one amendment. We figured that'd be a lot cleaner for you, Senator.
Okay. I know we've had a lot of questions about the dips and dunks. Could you explain a dip and a dunk to me?
So back in 2015, legislation was passed and enacted that said, as opposed to so a technical violator, okay? A technical violator is somebody who comes in, they're on parole or probation. They show up, they fail their drug tests, or they didn't show up on time, or they didn't show up at all. That's a technical violation. Before 2015, those people went back to prison. They didn't commit a new crime, but they went back to prison. What dips and dunks did was it said, but there's got to be a way to penalize them without sending them back to prison. So dips were, first time you offended, you went for 3 days to a jail where you were held to kind of make you realize, hey, don't mess up again. So there's a series of dips. Then the more serious technical violators became dunks, which means you can serve it 45 days in a jail or prison. It's basically a way of making sure they stayed on the right path without sending them back to prison altogether.
Kind of giving you a taste of remembering what it used to be if you want to go back to this.
If you want to go back, this is what it's going to feel like. And it's a disciplinary issue. Now, let me say this. As far as people on technical violations, Alabama's now the third lowest in the country as far as technical violators going back. And I can tell you that recidivism rate has gone down among that population. So the dips and dunks do work.
Yeah, you get a little taste of it.
Senator Weaver.
So you and I were legislative partners for many years, so it's not going to surprise you that I'm a little bit of a nerd and I'm going to ask some nerd questions here.
You should, because I will say it's a confusing issue, yes.
So you're right about insomnia. At 1 o'clock this morning, I had this in my hotel room, still trying to go through 92 pages, and it's a lot, and it's a lot for me to process. It's, from what I can tell, it's probably mundane technical changes and a lot of it, but it's not easy for me to see what this bill actually does. There's some code numbers that swap out for other code numbers, and I was sitting there in my hotel room trying to pull that code on my phone and trying to match it up, and I was having a really hard time. I guess the part that concerns me most is, I know you said there's no policy changes, but there's a lot of discussion about how we manage geriatric inmates. And I know that there's a lot of cost related to that and how we appropriately manage them in the appropriate part. There's some parts about a risk assessment tool that I still have a lot of questions about. I don't thoroughly understand. And again, it's a lot for me because this bill is so long and I'm trying to process, and Again, I just,
We don't address, Senator, what we didn't do. And I think you're right. I think there's a very valid policy discussion that needs to be held on our geriatric population, mental health population. What I wanted to avoid, and the reason this is so long, is because we went code section by code section to address the name change, to delineate that in 2019, these are the duties for this bureau, these are the duties for the board. We didn't want to do any policy changes such as some of the concerns you raised, mainly because I felt like we were now going to bite off more than we could chew. I just want a technical change, and it is long, it is confusing, and I agree with you.
so, I'm a little gun shy based on the length of bills and what I've dealt with some in the past that had some unintended consequences in it. So for those issues like geriatric inmates, should we not be having a full-blown conversation about that instead of just addressing it like a little line item?
I think you should, but the reason I don't do it in this bill is because what you just said, it was so long, it was so detailed, and it's so convoluted, and it is technical. It could have been an ALI bill easily because it's just a bureaucratic change. I do think we should have those changes. I mean, those ideas and debate. However, I wouldn't do it in this bill because we're going to get a Christmas tree that's too heavy with too many ornaments. It's going to fall over. I think the idea, though, the better route would be to have standalone issues to tackle it. What I've noticed on bills that had a lot of policy change, particularly if this 91-page bill had nothing but policy changes, I would never be for it, because if I were in your shoes where I was at, it's too much at one time. I think we tackle you tackle geriatric, you tackle mental health, but you do it in silos so that you accomplish your goals for the issue you're concerned about without having some omnibus bill on parole, probation, prisons. That's the problem, the correctional system today, or criminal justice system, is we try to do these large overhaul of policy with 10 issues. It just doesn't work.
So I guess in this, I'm still trying to process, like, in that discussion specifically about those topics, how do we know that there's not some unintended consequence that is in here that's going to affect the way that we do things going forward about that?
Well, Senator, I can tell you for the last 2 years, I've worked on this bill. Actually, 2.5 years we've worked on this bill through LSA. We've worked on it through our staff. And I can tell you that in my experience in the criminal justice realm, and that's going on a couple of decades now, I don't see the unintended. The only thing that's changing in here is bureau, you're in charge of this, board, you're in charge of this. But it doesn't address who gets paroled, who gets probation, who doesn't get parole, who doesn't get probation, who doesn't get a pardon. All it addresses is right now, as the law stands, clarifying that in certain situations, I do this, the board does this. So we don't address any of that. And I feel confident in saying that this bill doesn't address any, I will say it doesn't address any policy issues. So I don't think there are unintended consequences. I don't think you're going to see, it doesn't even address this. No one's going to get out early. No one's going to stay longer. No one's going to get special privileges based upon this bill.
I guess I'm thinking about all the work that was done in 2019 when Connie had it and when you had it, and
which was a good bill. Hey, I was a sponsor, so I agree.
Yeah, and it's just a lot for me to process.
I will say this is a lot, and I've been around doing this for a long time now. 3.5 years, 2.5 years doing this. I can tell you that's like 20 years, but it works.
Senator Elliott.
Mr. Chairman, I need some more time with this bill before I'm prepared to vote on it.
Yeah.
I'd like to.
Okay. Well, let me just, for clarity purposes, you see the big amendment, multi-page amendment, I believe, that's in your package. There's also a short amendment. I think we need to try to meld those two together to the extent that we can.
Move for adoption of the amendment.
Well, let's hold off on that. Let's get them in a better format, because there's actually two different amendments.
Mr. Chair.
I think this encompasses I think this one, the big one, brings that one in. Yes.
All right. Well, let's do this. We're going to take some other comments and we're going to carry it over till next week.
Now, I just have a question. I just know for me, when you have an amendment that's really thick and a lot, that it's often better if you just do a substitute and it's cleaner. And then in that way, you don't have to take the amendment and the bill and insert what the changes are or whatever, and then go back and try to make sense of it. So I would just, submit that maybe you should think about doing a substitute
Good.
instead.
We've got a little time between next week. We'll try to work on doing that.
And
Valid point.
Mr. Chairman, I was Senator, and we talked about that, and the only reason we didn't, and it was just a,
Well, and I understand,
I think
but,
you're right. I
but
think
in
you're
lieu
right.
of the conversation that you just heard, maybe that would be the best
We were
thing.
concerned about dropping this enormous substitute today, and you go,
I understand.
what in the world are you trying to pull on us here, Senator? I mean, come on now.
It sounds like that's what you're still being asked, but
That's okay. Yes, ma'am.
but
All
thank
right,
you.
as bill
Thank you, Mr.
sponsor, thank you, Senator Figures. The bill sponsor will carry this over. We're going to try to work on getting a substitute that encompasses any amendments that need to be made. Representative Pringle, is he here?
Thank you, Mr. Chairman.
Thank you. Representative Pringle, come on up. I didn't see you hiding out there. HB 82.
Thank you, Mr. Chairman, ladies and gentlemen of the committee. HB 82 is a bill that's passed the House and come out of this committee several times. It's several years ago, a friend of mine's son got addicted to Oxycontin, and they sent him to rehab. They mortgaged their house and got him cleaned up, and his drug dealer would sit outside the Narconon meetings and just harass him when he came out, to the point where the boy changed his telephone number and got a new phone because the drug dealer just kept calling him and calling him and calling him. And the drug dealer went so far, he went and knocked on the boy's mother's door and said, "Your son showed me a piece of property about 8 months ago, and I'd really like to buy the piece of property, but I can't get in touch with him." So the mother, thinking it was a real estate deal, gave the drug dealer his new cell phone number. And he kept calling the boy and wearing him down and wearing him down. And he sold him an Oxycontin that was laced with fentanyl, and it killed him. We know who sold it to the boy. We know who killed him. And this bill would allow us to charge that person with manslaughter. These drug dealers, as crazy as this sounds, if they're not selling enough drugs on the street, they will actually up the amount of fentanyl in their drugs in order to kill people because their drug sales go up. All this bill says is if you are not a licensed pharmacist or a doctor and you sell a controlled substance and it causes somebody's death, we can charge you with manslaughter.
Senator Bell, motion favorable. Senator Gavan, second.
Well, I have some.
Senator
Let me get
Figures?
your second first, but I have a question.
Senator Figures, you were asked.
Mr. Speaker Pro Tem from Mobile.
Thank you, my esteemed colleague.
How would they go about proving that?
Well, I mean, to raise the level of manslaughter, you have to have evidence. And in this case, we have proof. We have somebody that witnessed the transaction. So, I mean, it's a high standard. You can't just prosecute everybody. But if we know that you sold the drug and you caused that person's death, then we can charge you. You have to prove it. I mean, it's not automatic, but yeah.
Okay. I mean, my heart goes out to that young man's family. I can't imagine that. Thank you, Mr. Chairman.
Thank you. Thank you for bringing this bill. We got a first and second. Any opposition using previous roll? Senator Albritton be added to the roll. Bill is given a favorable report. Thank you. Thank you. Thank you for
Thank you
bringing
all
this.
so much. I appreciate
Thank
it.
you. All right, Representative Simpson, HB 76. No, you got someplace you have to be, and I apologize. We've taken a little bit longer than I anticipated to get to you, but
I am
the
at
floor is all yours.
I'm at the mercy of the committee, Mr. Chairman. Thank you very much. HB 76 came from what happened in Daphne. We had a guy who got into a argument with his grandparents. He went to their house to try to kick in the door. He was arrested. The only thing they could charge him with was criminal mischief. They could not put a hold on him. They could not put a no contact provision because there was no domestic violence provisions in the law for grandparents. He bonded out, went and killed both his grandparents and 2 other individuals at the house as well that day. If this law, the purpose of this law is to allow for the hold to be placed, to allow for the provisions to be in place where if a grandparent is the victim of domestic violence, that's where it came from when we originally filed it was grandparents. The committee and Judiciary added step grandparents and grandchildren as well to the potential victims of domestic violence.
Mr. Chairman, I'm for
Senator
favorable
Figures.
report.
Got a motion for favorable. Senator Figures, Senator Gavan, second. Any further discussion? Any opposition using previous roll? Thank you, Representative Simpson. Thank you for bringing this bill.
Thank you, Mr. Chairman, members of
Yes.
the committee. Thank you.
Thank you. Senator Schofield, come on down. You're the next contestant.
The price is right.
Senator Schofield, tell us about your bill, please, sir.
Thank you, Mr. Chairman. Members of the committee, this bill has been a lot of work. And then first, I want to thank you for helping to, I think your words have been moderate a lot of discussions that we have had on this with the various parties that have been interested. I want to thank them for all dedicating a lot of time to getting some relief for our partners in the road building business. The situation is pretty easy to understand. Our road building partners, we as a state, our counties, our cities rely on them to provide an important service for us. They're in a unique position, however, that the state of Alabama has sovereign immunity. They can't be sued. They can't be held liable. Our counties and cities have a cap. So that means most of that liability is placed on our road building partners. So this bill was, I believe, a successful effort to give them some relief. And I'd be, we through this process wound up, I think, making all the interested parties happy with it. So I'd be glad to answer any questions. Essentially, to tell you a little bit what it does. Obviously, if you are driving under the influence and you wreck or you are a distracted driver, that road builder should not be held liable. It does other things. We've added sort of the med-mal practice as well. You have a situation to where these folks are on the hook for 7 years. The statute of repose is 7 years. So once they complete a project according to state specifications, county specifications, or municipal specifications, and that awarding authority takes control of that road, it's up to them to maintain that road, right? That's not up to the road builder. That's not in the original contract. Therefore, they would not be held liable. So we have created a delineation there between the two. And Mr. Chairman, I'd be happy to answer any questions.
Move adoption of the sub.
Motion for adoption of the sub by Senator Gavan. I'll second that motion.
No, but I had asked first, Mr. Chairman.
Sorry, ladies.
Well, you recognized me after go on, Senator Coleman. Madison, since he can't make a decision, I will.
I can make I can make one. I'm just not sure that
it's not a battle. It was a matter of fairness, but go on, Senator Coleman. Madison.
Senator Schofield, can you tell me what
in
Judiciary?
What's the difference?
Pardon? Can you tell me what changes are in the sub?
The changes in the sub, I can run through the talking points, and I'm going to need to because, Senator, we have worked very hard on this, and we have had many different drafts. So if you will,
Senator Coleman Madison, what was the question? I apologize.
The difference between the original bill and the sub.
Well, let me try to address that in broad terms.
I just want to know what's in the sub that that you all came to an agreement, because of course we've heard from both sides. I'm interested.
If I can't give some general idea, Senator, your bill, but if you don't mind, I think the bill is originally drafted, call for no exceptions. This bill does call for some exceptions. It tightens the language on what must be done at the filing of a complaint by an interested party. And it does, as Senator Schofield mentioned, have some language in there about distracted driving or DUIs as a proximate cause of an accident. So those are some major concessions, I would say, by each or all of the interested parties that does in fact I think, continue to give the road builders of the state of Alabama the ability to continue to conduct their business without being, in their opinion, unfairly targeted, while balancing that with the needs and the rights and the safety of those citizens that we represent.
Mr. Chairman, may I?
Senator Figures.
Thank you. Senator Schofield, I know that you've gotten together with various parties, but I didn't hear you mention the county commissioners, because I had gotten calls from both of my counties, so they're okay with this one.
I think it would be fair to say that they are supportive of the bill.
Right, I had just sent a text to one of my commissioners, but I haven't heard back yet. So thank you.
You're welcome.
Thank you, Mr. Chairman.
Thank you.
Thank you, Senator Figures. All right. Any other questions, comments, concerns? Got a favorable on the adopted sub by Senator Van. Got a second by Senator Coleman Madison. Before we take the roll call, I want to add some personal comments. So I know you've been passionate about this issue for the last several years, and it has been personal, and you have worked long hours, days, years to accomplish what this committee is, I think, going to accomplish. And I applaud you for that. Hats off to you. You've taken an issue that in your mind needed to be resolved, and you've accomplished that. So again, congratulations and hard work and your effort that you put in. I'd also like to say thank you to trial lawyers, to the County Commission Association, the League of Municipalities, and the road builders, obviously, who are here. I think, but for your leadership on this and getting all the parties together to come to a resolution, we probably would not be here today.
Thank you.
I meant what I said earlier about a balancing act, and it is a balancing act. And I think we have struck the right accord, seems to me, balancing the business, the industry, the road builders have, and the necessity and the need for them to continue to be able to pave and maintain or adequately provide us the roadways that we need to travel safely on the state of Alabama throughout the state, while balancing that act with the safety of the folks that we represent. So my hat's off to you. Hats off to all of those parties that I mentioned. It's also an effort to make sure that all voices are heard in a room and to come to an agreed upon solution. And I think that's extremely important.
Yep. And
I thank you for your efforts.
Well, thank you.
Thank you, sir. Any opposition using previous role? Hearing none. SB 159 receives favorable committee report. Thank you, Senator.
Nope. Thank you, Mr. Chairman.
Yes, sir.
Members, thank y'all.
Okay, I think the last bill on the agenda we have today is SB 245. When we talk about monstrosity of a bill, this may get the award this year. It's 921. Senator Gavan, I'll let you take off.
So, yeah, I was laughing when Cam referred to having an insomnia bill. I'm like, I got your insomnia bill here. And I will make this confession. I have not read this bill. This is an ALI bill. I dropped it. There is an issue on when it would start, because this would change the way we deal with nonprofits. And the Secretary of State, which, has a concern about when they can get their forms lined up to comply with this and want a little extra time. I'm personally amenable to that. Don't have the amendment right now. They're asking for 6 more months to be able to digest all this, assuming that we do pass it. I see a question across the way with.
No, this is not a question. It's just
Senator Cole-Madison.
a recommendation or an ask if you could do us a little cheat sheet summary of exactly what, because
There is a cheat sheet, and what legislative day are we on?
17 just today, I believe.
I think this has already passed the House, So why don't we, to deal with the amendment, let me get a chance to get the cheat sheet to the members? Why don't we carry this over to next week?
Thank you.
Very well. I think that's a wise thing to do.
They do have a cheat sheet. I'm sorry I didn't bring it.
I'm gonna say this though. So there are bills that come through up here, and I shouldn't say this, but I'm gonna say it anyway. There are bills that come up here that, you know, you skim through and you think you understand. There are bills that you really spend a whole lot of time on, and maybe you do and maybe you don't. And quite honestly, I could read this from now until Christmas time, and I'm not sure I'd understand every bits and piece of it. So I appreciate your willingness to work on it, to bring it, to make sure that it does what it needs to do or what we're trying to accomplish here. So, all right. Any opposition carrying that bill over? Hearing none, we'll carry that bill over. I believe that we have gotten through the agenda for the day. Yes, we did handle 76. So that being said, members, the meeting's adjourned. Thanks so much.